I rise to discuss the vacancy on the Supreme Court and the majority's ongoing refusal to consider the nomination of Chief Judge Merrick Garland. 40 days have passed, Mr. President, since the President of the United States nominated Judge Garland to fill the Justice Scalia's seat. This is longer than it took the Senate to confirm Justice Sandra Day O'Connor in 1981. In fact, 75% of all Supreme Court justices have been confirmed within 31 days. But today, 40 days after the nomination, many senators haven't even extended Judge Garland the simple courtesy of a meeting, and we don't seem any closer to holding a hearing. The majority's refusal to hold a vote is without precedent, and the majority has cited none. Instead, the majority is trying to shift the blame. Incredibly, the chairman of the Judiciary Committee recently came to the floor to blame, of all people, not other senators, not other politicians, but the Chief Justice of the United States of America for politicizing the court. 10 days before Justice Scalia's death, the Chief Justice said, quote, "The process is not functioning very well." That turns out to be something of an understatement, Mr. President. Chief Justice went on and said, the process is being used for something other than ensuring the qualifications of the nominees. Again, he wasn't referring to what's going on now in the Senate. This happened before Justice Scalia passed away. There was no way that the Chief Justice was going to know that there was going to be a vacancy. He continued, Supreme Court justices don't work as Democrats or Republicans. And I think it's a very unfortunate impression the public might get from the confirmation process. His words struck me, and particularly given what's gone on since, as a candid expression of his concern for the court as an institution. But this concern apparently upset the chairman of the Judiciary Committee. He took to the floor. He came down here to say that the Chief Justice, quote, "The Chief Justice has it exactly backwards. The confirmation process doesn't make the justices appear political." He said, quote, "The confirmation process has gotten political precisely because the court has drifted from the constitutional text and rendered decisions based instead on policy preferences." It is absolutely breathtaking, Mr. President, that the Chief Justice would be criticized for, quote, "drifting from the constitutional text," when for the past 10 weeks, the majority has drifted from Article 2, Section 2, Clause 2, which sets out, in very clear terms, sets out our constitutional responsibility to advise and consent. And worse, the majority's drift isn't even about policy. It's about politics. It's about rolling the dice on an election instead of following the plain text of the Constitution. This is absolutely unprecedented in the history of the United States Senate. Throughout our history, the Senate has confirmed 17 nominees in presidential election years to serve on the Supreme Court. The last of these was Justice Kennedy in 1988. In the last 100 years, and I should say, when the president made this nomination, he had more than 340 days left in his term. We're talking about almost a quarter of the president's term. So that's a lot more time than most of these 17 justices were before the Senate. In the last 100 years, every nominee to a Supreme Court vacancy that did not withdraw, and a couple did, received a timely hearing and a vote. On average, the Senate has begun hearings within 40 days of the president's nomination and voted to confirm 70 days after the president's nomination. There is no excuse for not holding a hearing and a vote. The plain language of the Constitution, if that's what we are going to pay attention to in this chamber, if that's what we're going to argue for, originalism, strict constructionism, the plain language is clear. And there's a reason why no Senate has ever had the audacity to do what this Senate is doing right now, because how clear that mission is. And there's no one else to do it. The Constitution says the Senate shall advise and consent. Doesn't say the House of Representatives shall have a role. Doesn't say let the people decide. It says this is the Senate's job, and we should do our job, as every Senate has between now and the founding of the country, including the Senate that was there when George Washington was there. 3 of those 17 appointments were confirmed by a Senate that actually contained people who had been at the Constitutional Convention and consistent with their understanding of what the founders had agreed to, had a vote on the floor of the Senate. I'm not saying how people should vote. They should vote their conscience. But we should have a vote. The American people expect us to do our job. Finally, Mr. President, let me say a word about the President's nominee. And I want to be clear that I believe there should be hearings, and I think we should go through hearings to establish the qualifications of the nominee. I think that's really important. And the point that I'm making about having this vote does not have to do with whom the President nominated. It has to do with our institutional responsibility. It has to do with the rule of law, the image we want to project to our country and overseas. But let me say a word about the President's nominee. Merrick Garland is an honored and accomplished judge. 2 weeks ago, I had the opportunity to meet with him and learn about his judicial record and his philosophy. I have known Chief Judge Garland for more than 20 years and actually worked for him at the Justice Department when we both worked for the Deputy Attorney General of the United States. I was fresh out of law school, but even then, Judge Garland's humility, his work ethic, and commitment to the rule of law inspired me. It continues to inspire me. Our meeting last week confirmed for me what I already know. Judge Garland is an intelligent and pragmatic judge who is extraordinarily well qualified to serve on the Supreme Court. And I've wondered, Mr. President, whether it's for that reason that the majority is not holding hearings, instead of simply holding the hearings and then voting against Judge Garland, which is their prerogative. Why not hold hearings? Maybe they know that the American people, given an opportunity to hear directly from Judge Garland, would see that he is precisely the type of judge who should serve on the court. A vacancy on the Supreme Court is a rare thing. It doesn't come around very often. And for those of us in this country, whether we're in the Senate or whether we're in a classroom somewhere today, those vacancies and those hearings and those debates on the floor present an unparalleled opportunity, a remarkable opportunity for the American people to engage in a debate about the court, about the Constitution, about all kinds of issues that the court will consider. That's what these hearings are about. That's what could be going on this summer in this presidential election year. We could be having a discussion about where we want to head as a country. We're not having it. We're not having it because of this unprecedented action. And because of what the majority has done here, without saying we're not going to meet with the candidate, the nominee, we're not going to hold a hearing, they're denying him the opportunity to make his case to the American people. And in the meantime, and this is really critical, the court will continue to be impaired. Impaired. That is the word that Justice Scalia himself used when he was asked to recuse himself from a case involving Dick Cheney, then the Vice President of the United States. And he was asked in that case, he said, we should have a presumption of recusal. And Justice Scalia's answer to that was, maybe if I were on the Court of Appeals. Because if I were on the Court of Appeals, there'd be somebody to replace me. But that's not how it works on the Supreme Court. In the Supreme Court, when you have a vacancy, there are 8 justices. There is nobody to fill in. There's nobody to become the 9th justice. And the court, he said, would therefore be impaired. What is the action that's being taken right now threatens to impair the Supreme Court, not for one session of the court, but for 2 sessions of the court before there's another election. In fact, for the 3rd time Since Justice Scalia's death, the Supreme Court could not resolve a dispute because of a 4-4 split. And the longer this vacancy remains, the more uncertainty and confusion the American people will suffer. 2 terms of the court, as I said, will be jeopardized by petty politics. I know, and believe me, Mr. President, I know, it has become fashionable for Washington to tear down rather than work to improve the democratic institutions that generations of Americans have built. But to impair so cavalierly the judicial branch of our government is pathetic. It's time for the Senate to do its job, as every Senate before us has done. And again, I am not asking my colleagues to support Judge Garland's nomination. That's a matter of conscience for each of us. But we must fulfill our basic constitutional obligation of holding a hearing and a vote. This is literally, because it's in the Constitution and no one else has granted this power, this is literally the least we can do to demonstrate that we are a legislative body that functions as the Constitution requires. We certainly have plenty of time. And in view of that, if by contrast we leave for our scheduled 7 weeks of summer vacation, something that is not enshrined in the Constitution, but a schedule that's set by the Senate, if we leave for our scheduled 7 weeks of summer vacation without having fulfilled our responsibility, the American people should demand that we return to Washington and do our job. It's past time for my colleagues to meet with Judge Garland, to hold hearings on his record, and to give the American people an up or down vote on this judicial vacancy. Thank you, Mr. President. I yield the floor.